Afternoon and good evening. Oh, there we go. Good morning, good afternoon, and good evening. Welcome to the American Bar Association section of International Law, Committee on International Transportation. Our discussion today is on the adoption of electronic bills of lading. This critical document remains paper-based in many places, with shippers requiring the original document to be able to transport goods. If they can be adopted, what will be the result? We'll explore that question today. My name is Rebecca Fenneman, and along with Jason Dwyer, I'm the co-chair of the Committee of International Transportation. We're so glad you could join us today to talk about this important topic. A quick word about the ABA, the section, and the committee. Founded in 1878, the American Bar Association is a member organization of lawyers created to advocate for the profession and the rule of law, and to serve its membership by promoting programs to promote members' professional growth. The section of international law is the leader in the development of policy in the international arena, the promotion of the rule of law, and the education of law practitioners. If you haven't already, please consider joining and participating in the International Transportation Committee. And if you have any questions about how to do that, reach out to me directly. We're so pleased today that over 100 registrants are joining us from many parts of the world to hear from lawyer and expert on electronic bills of lading, Boaz Lessem. Boaz is joining us from Tel Aviv, where he serves as head of legal product at the Tel Aviv-based eBL, the electronic bill of lading platform, where he's been since 2017, and I've heard he was the second employee of eBL. He led the design of the platform's legal framework through the approval in December 2019 by the International Group of P&I Clubs. Boaz has worked with industry groups focused on the digitization of trade finance, interoperability between platforms, and advocating for e-bill of lading adoption and use. He's advised law reform groups across the globe regarding required changes to the legal regime, including the adoption of the UNCITRAL Model Law on Electronic Transferable Records, MLETR. Welcome, Boaz. Thank you so much for joining us today.
Thank you very much, Rebecca.
And Boaz will first lead us in a presentation running about 40 minutes, I think. And then we'll have some time for questions and answers. But before that, we'll be joined by Luca Castellani from Vienna, and I will introduce Luca at that time. Boaz, do you want to take away the presentation? Thank you.
Yes, thank you very much, Rebecca, and thank you very much for all the participants here today who have come across to listen to our presentation here, to my presentation, and then to Luca's very interesting insights, which I hope he will bring us. We're going to try in the next few minutes to express and explain what are the challenges of digitization sitting before the bill of lading, which is a very, very ancient document that we are all anticipating for years for it to actually digitize and become electronic. And that's what I'm going to intend on speaking about in the next hour and a half. And later on, we'll have some time for questions, and there are a lot of questions about this. So let's start. Can you see my screen?
It looks good.
Looks good. All right. So, just a second. All right, so today we're going to discuss the electronic bill of lading and the commercial benefits and legal roadblocks for this to actually to take place. As Rebecca said, my name is Boaz Lessem, and I've been working at eBL since its almost since its creation or inception. And what we did in eBL will be explained later on. It was done also by other platforms, but may have been achieved in different ways. WaveBL was the first electronic bill of lading platform that was based on using blockchain ledger. If before that we had different participants in this field which used the technology which is more familiar with called the centralized technology, which is opposite to a blockchain technology or decentralized technology, then Wave introduced this concept first. And I started working here back in 2017. And what we did at Wave was to take the Carriage of Goods Act law and digitize it into technical rules, which we'll express later on. But before I'm going to talk about WaveBL, and I have to talk a bit about my work here in our wonderful platform, I would like to speak in general about the bill of lading and the electronic bill of lading. So let's start from what exactly is a bill of lading. And I know I have a wonderful audience here, which is probably all familiar with what a bill of lading is, but let's try and remember together again. So a bill of lading is a document of title. And that's a very significant and important thing. It's not just an original file, original document. It's a document of title, and it has a meaning. It's legislated by the law in almost every jurisdiction around the world. And it serves also as a receipt, which is granted by the carrier of the goods in returns for the goods that have been loaded to the ship. And the contract of carriage is part of it also, and it sets the terms and conditions for which the goods will be transported. I added a few more things which are very important to understand about a bill of lading. A bill of lading, we all know, is an autonomous document. It has to be unique, meaning it can have copies, but everyone has to know at any distinct moment that they're holding the original one, the unique one. And I try to stay away from the word original and use the word unique because it is more easy to understand the big technological and operational challenge that we have here. It needs to be confidential. If you hold a bill of lading, a paper bill of lading, nobody is supposed to know that you're holding it except the party who gave it to you. And they can assume that it's still held by you, but they can only assume it. Nobody knows where it is. And the subsequent possessor who surrenders the bill of lading in return for the goods, he's not supposed to know where this bill of lading was before he surrendered it, unless, of course, there are different endorsement signatures. But a paper bill of lading doesn't speak, it doesn't have a voice, and it's confidential. And obviously, it allows third-party rights, which goes back to the document of title, and that's a very important part that we need to remember, and we'll discuss different impacts of that later on. So from a BL to an electronic bill of lading. So first of all, why do we need to go digital? So yes, we want to slash down transfer time. We all know, we all suffer from the pains of transferring documents in parallel to goods, and they arrive later on and they have mistakes and they need to be amended. And in the end of the day, this leads to demurrage costs. And thinking about this in 2023 sounds crazy, but that's reality. And we want to remove that factor, the documentation time factor. The risk of forgery. This is something which is inherent in the paper world, the risk of forgery. And it could be reduced significantly in the digital environment if digitized correctly. And that's very, very obvious for very, very obvious reasons how that is done and how that could be achieved. We can discuss that in details later on if we want, but basically it's a good assumption to understand that forgery in the digital environment would be less taking place than in the paper world. We don't need multiple copies. We're all familiar with bill of lading having several copies. We don't need them in the digital environment. It doesn't mean that they cannot exist. You can issue 3 different copies of the same original and decide that you need all 3 to perform actions. 2 of them, as long as that's defined in advance and everyone understands that it could happen, but there is no real need for that. And we eliminate partial solutions such as telex release and seaway bills and different indemnifications that the world has got addicted to. And all these solutions, in the end of the day, are compromised. They're compromised, and they compromise on different risks, and they make things more complex. And they are, if they could be removed, I guess everyone would be happy to remove them. And all this obviously has less cost reducing, and we can also add environmental issues of not using paper and not transferring the documentation and not returning it back and forth. And these costs could be reduced significantly. Now, a mass eBL adoption will eventually lead to what I like to refer to as the digital dividend, and I'll talk about that later on, but these are things that we could see only in the future in the world of mass adoption. When we are early stage adopters or users, we won't see these significant issues of the digital dividend. We will see the things that we just named before. The biggest benefits would be achieved years ahead from now. So, yeah. Any change in the size that you see, or just me?
No, it does need to, yeah, there we go, perfect.
Okay, so an eBL stands for an electronic bill of lading. From all trade documents, we need to understand that digitization of the BL is the cornerstone for digitization of all other documents. An eBL, it may look like any other document, but it's unique. And all the following attributes need to be achieved by an eBL platform. It needs to track possession. This is what we track on a platform, the whereabouts of the bill of lading, the electronic bill of lading. That's what we track. It needs to indicate the title holder at any given time. It needs everyone to agree in advance what is each party allowed to do at each situation. And it needs to agree in advance what each situation means in legal terms. And to be achieved without harming the original attributes of a paper bill of lading, such as autonomy, confidentiality, and tailored negotiability, which we discussed before. This means that in our business of eBL platforms, we haven't invented a product. We took the bill of lading, which is a product which was facilitated by the regulator hundreds of years ago, and we digitized it to be exactly the same as it is in the paper world, because otherwise we're creating a different product. And the bill of lading is wonderful, and none of us want to get rid of it. We want to keep it and preserve these different attributes of it. One of the benefits of having this whole thing digital is removing a lot of questions that could be raised and need for human involvement in assessing the status of the bill of lading. Because if the title holder is defined in each state of the bill of lading, and if everyone agreed what that means and what will be the authorizations of each possessor in this case, this is how we lead the stages to future automation. And automation is the real reason why we're going for electronic bills of lading. Not just to make life easy, to make this whole thing work faster, safer, and more secure, and in more certainty. So what is an eBL platform? So when I spoke to Rebecca a few days ago, I gave her an example which I like to give. An eBL platform is a tree. It's a tree which we all agree to mark on who is holding possession at every moment. It's a registry. It's a ledger. This tree serves exactly as that. We all agree that each platform for some instance or for some document is going to serve as the ledger which is agreed on everyone to say, indicate at each exact time who is the possessor and the subsequent title holder of each bill of lading. And once we have that all agreed, then this is the exact service that we go for when we use an eBL platform and not just send PDF documents on email without having any platform or ledger involved. The second thing that an eBL platform needs to provide is a clear binary legal regime, as I said before, as a ground for automation. The law in the applicable jurisdiction needs to provide clarity regarding that. Now, all platforms basically are compliant or subject to English law. And we'll discuss in a few minutes about English law and the significant change which the UK is going through right now in that case. But it has to be understood that if the platform will be subject to a law in a jurisdiction where an eBL is restricted or definitely not allowed, that will be a problem. we need to have clarity that the jurisdiction where the eBL is, the platform is working at, has the ability to work in that jurisdiction. The second thing is the contractual legal framework that achieves clarity between all players from different jurisdictions. Now, there are a lot of discussions about this, and it's used to be seen as a blockade or some kind of obstacle to adopt an eBL platform. The fact that there are contractual framework, or some call them, we call them, at least on Wave, we call them bylaws. There are different definitions for that. We see this as a very, very imperative document, and actually a document that has a lot of benefits, because a bill of lading, by definition, travels between at least two different jurisdictions. And it may be possible that the issuance jurisdiction or English law, an electronic bill of lading is legal or valid. But in the subsequent jurisdiction where the consignee resides, or subsequent endorsee, that is not the case. And we want clarity. All the players in the platform regarding this eBL, they want clarity. They want to know that all parties that may potentially touch this eBL have agreed in advance to a contractual legal framework that achieves clarity and will somehow not be challenged by their jurisdictions if that is not clearly legal at their jurisdiction. And that is why we see these bylaws as a very significant and important framework, which is going to remain even after all legal reforms or law reforms across the world, because we see it as a positive thing and not as a negative thing from our experience. And this could be discussed later on. Maybe Luca would like to say some things about that at a different stage. And the IGPNI approval. So we discussed that before, when I started at Wave in 2017, what did we do until 2019? So we did POCs, proof of concepts. Everyone said, wow, what a wonderful platform. But nobody really wanted to issue commercial bills of lading. And why? Because their insurance, their liability as a carrier wasn't covered. And the body who is supposed to cover their liability, the International Group of Protection and Indemnity, the IGPNI, they need to officially approve and say that some kind of electronic platform is from now onwards, their bylaws are approved and their insurance would be covered, the carrier's liability would be covered on that platform. And effectively, that serves as the go-to-market moment for each platform, where that approval allowed the carriers to have the commercial possibility to start issuing bills of lading on our platform. And across the years, the PNI clubs are the ones who approve all the platforms, from Bolero and ESS Docs at the earlier days, later on, the ones who joined later on. And today there are 8 platforms, and 6 of them are blockchain-based. We can discuss the role of blockchain later on. Wave is a blockchain-based platform. I think there's a very big reason why blockchain fits for eBL very much, and why it's adopted by a lot of platforms and quite acceptable today across the world as a good solution. The main reason for that is that this is international trade, and there is no real regulator that has the ability to create an acceptable registry, which will be acceptable on all governments and all carriers, freight forwarders, and effectively any company in the world who exports and imports. That's not a realistic expectation. And blockchain is just fit for that. And it allows to manage the transfer of the documentation without involvement of the service provider, being an agent or anything like that, as part of the transfer of rights and liabilities in the bill of lading. And now I said I'm going to talk about the digital dividend in the future. So when most market will go electronic, then what we will actually receive, and that will take a few years from now, probably at least 5 to 10 years, we will have accurate real-time data, and we will streamline business workflow. Systematic risk will be reduced regarding trade, and that is, the holy grail of it all: access to new funding and to new collaterals, which today don't have that access. And we need to remember that bills of lading could have access to funds, but because they're on paper and because the goods travel in sea for a few weeks maybe, there's not enough time to start going around banks and financial institutions and finding different schemes for funding. Digitization will allow eventually parties to receive funding instantaneously if different conditions are preset conditions are achieved. And that will be the future. For that to happen, we need a lot of electronic bills of lading, and that will eventually be the case. So now I'm going to touch a bit of the legal and regulatory challenges. So all platforms currently work under English law, and digitize the applicable law which legislates bills of lading in the UK, in England, which is called the Carriage of Goods Sea Act, COGSA, 1992, not to be confused with the previous ones. And what I did together with my UK counterpart lawyers, who I've owe a lot, helped me a lot with this work, is we followed this law and we created a system with rules that work exactly like that law. And the fact is that all the other platforms have done the same. Their lawyers have done the same, but they achieved it a bit differently. And we have to remember that in the end of the day, when a law is interpreted by lawyers and developers, it could be interpreted a bit differently. And the actual product will look different and have a bit of different attributes. So we have to remember that we can say that it's compliant with COGSA, all the platforms, obviously, if they're approved by the P&I clubs, but they may have differences in the way that the product looks, the way the product acts, and the way it was interpreted by the lawyers who created this kind of framework. And MLETR, the Model Law on Electronic Transferable Records in 2017, in Europe it is called, or in England it's called MLETR today. It serves as an easy guidance for regulatory transformation. Luca will say, I hope, some words about that later on. I can say that MLETR has some very fundamental principles which could be used and in a law reform to accept or transform to the acceptance of electronic bills of lading. But also me, as someone who created a framework for a platform, I read this document back in 2017 and took some very significant issues from there that were raised, like the right to switch to paper, which has to be accepted by the issuer of the document without any doubts, like the definition of control. And it's a very, very significant and important document in the history of the adoption of the electronic bill of lading. And later on, this document led, following a discussion in the English law, to the Electronic Trade Documents Bill, which is currently in English Parliament and is supposed to pass in the next few weeks or months, and is going to change English law. And it has a significant impact. It's going to have a significant impact on the digital transformation. So at early days, until 2018, I guess, it wasn't very clear if it's possible in English law to possess an intangible asset, to have control over an intangible asset. And an electronic bill of lading is an intangible asset. And that led to understanding that this uncertainty should be translated into a law which will make it certain that it's possible to possess and control and demonstrate control over a digital trade document. And this law, which I had the honor of participating also as part of the consultation paper that was published by the Law Commissioner of England, Commercial Law, has structured a list of several documents, which trade documents. One of them is the bill of lading. I think it's 8 different documents, which are now going to be part of that law and are going to be accepted in their electronic format. We have to remember, it doesn't replace the bill of lading applicable law, which is COGSA. It just says that electronic version would be accepted with some other important issues which are dealt in that law. But in the end of the day, it still needs to be governed by COGSA. It's just a bill of lading. We have to remember that it's not a different product. It's a bill of lading. And why is this law going to change a lot? So they say, so it said, 50% I heard of bills of lading in the world are subject to English law. Maybe that's true, maybe that's not, but I think it is. It's probably something around those numbers. And when English law until today is the law which was used by all platforms, had a bit of unclarity or uncertainty about the validity of an electronic bill of lading. Suddenly, there is a new law which says there is no uncertainty. This law, this bill of lading is fully acceptable in its electronic format. This is a big, significant change to the world. And I think that we all hope that the UK or England is not just another jurisdiction. It's a jurisdiction which the change there will help escalate what we're all anticipating, which is the full transform of the entire world market into electronic bills of lading, putting aside the fact that as we speak in other jurisdictions, this is taking place also, this initiative. And we can say about the US, the UCC, Article 7, electronic bills of lading exist. Electronic bills of lading are part of the law in several jurisdictions, also before MLETR was brought to the world. And it's not, there is no textbook way to do this. There is knowledge which is starting to be accumulated in different jurisdictions, how this should be done in the best way. But some jurisdictions are not anticipating MLETR because their jurisdiction, their legal regulatory regime accepts electronic bills of lading already. I have Sweden as an example, but there are a lot of other ones, just an example from the back of my head. So we all hope English law reform will actually change what we're all looking for. So earlier this year, I think, 9 of the biggest carriers in the world, which appear all in this list, have committed through DCSA, which is the Digital Container Shipping Association, to transform by the end of this decade to 100% electronic bills of lading, with a short-term goal of 50% within 5 years. And this is a game changer because the issuers of these documents are the carriers and obviously also freight forwarders. We can discuss that in a different discussion later on, what's going on in that field. But they're willing and their declaration that they're going to change and they're going to implement whatever is needed to do that means that we all, as lawyers in the maritime shipping industry and all the parties who work in trade, need to understand that we need to start changing our procedures and our perspective and look at the future, which is going to be an electronic bill of lading. And that's going to happen, and we're going to encounter these documents in the years to come very, very soon, more and more and more. So how is it going to increase? So the name of the game is the word interoperability, which maybe some of you have heard. And one of this word has a lot of interpretations. The thing is, there are different platforms in the eBL sector, and there are other platforms in other sectors, such as different trade certificates and other documentation and banking services, and they all need to talk to each other. And this is achieved by interoperability. And what we actually all want in the end of the day is to have easy access to a bill of lading. And the future will look like that. In the future, bills of lading would be received on emails, just like any DocuSign agreement that you're sent to sign. It will happen. It needs to pass some obstacles, but they're challengeable, and it's happening. And in the end, it's going to be seamless. If in the beginning, today, when you go and try and persuade a company to work with an eBL solution, you may encounter the legal department, then it's becoming less and less the case, and more managed already by the operation teams of each company, because it seems just like any other a digital era solution. It doesn't need to be too complicated to assess it. And that will be the future. DCSA is leading today POCs between the different eBL platforms to allow them to exchange bills of lading between them and to allow bills of lading to become fully interoperable between them. This is a very important initiative, and it will serve, I'm sure it will serve as a seed for later on interoperability between platforms from other sectors too, which are involved in trade. All right, so this is my part about the bill of lading. A few words I would like to say about Wave, which is my product. And maybe if we have a chance, and I think we have, I'll even show you 2 slides from how does an eBL platform actually look like. So we developed a product which is, as we said before, it's a ledger, and we're issuance driven. Our knowledge shows that in the end of the day, we start from an issuer, we start from a carrier, we start from a freight forwarder. We start looking together with them to onboard their customers, their shippers, and their freight forwarders. Later on, we help onboard their customers of customers, the consignees and the importers. And what we did is we used, as we said before, we used blockchain in a very distinctive way in order to promote that. And we have to remember that we are designing an application, a network, which is supposed to cater for the needs of a big carrier like MSC or Hapag-Lloyd, and also for the small SME in India or somewhere around the world, and also for a bank. All these kind of customers need to use the same in the end, or the same platform in the end, and it needs to cater for their different needs, and they have different needs. Wave is today one of the leading platforms. We are trusted and used by 4 of the biggest top ocean carriers. You can see publications about this everywhere, MSC and Zim, ONE, and Hapag-Lloyd, and list of a lot of freight forwarders are working on Wave already. Numbers are increasing month to month, and we have to remember this is about onboarding customers all the time to the network, making it easy for more and more for them, and the product becomes more and more intuitive and more easy to work on and to adopt like any other product, and that makes life easier. And once COVID arrived, and once people understood that digitization is not some kind of something which would be nice to have, it's more something which could become a need, that shifted the whole way that corporations and all of us look at this kind of product. In the end of the day, nobody can handle paper documentation from home, and it's a big issue when people work remotely. And definitely, if there will ever, God forbid, have another COVID event or something similar like that, it's just impossible to function. And that's why it became more and more understood that this kind of product is a game changer and a necessity for parties around the world. So a few words about blockchain, and we can again say more about that. So blockchain is a database. It could be considered as a database which is very inefficient, and I wouldn't recommend using it in case it's really needed to be used. And when is it needed to be used? When there is less trust between different parties using it. So to achieve trust between different carriers, banks, and governments and parties around the world is a big mission for everyone. And blockchain is very easy for that, to provide that kind of trust. And definitely nobody wants to trust the service provider itself to manage the registry and have access to all the possession whereabouts at any given time, and the data, obviously. Then in the end of the day, blockchain was found by us to be the fitting ledger for that solution. It's more safer because it has no single point of failure. It's separated, it's divided on a lot of different nodes around across the network, not only held by us as a service provider. So even if one of the nodes fall or somehow disconnect from the network, there is still continuity. It's the best way, as I said before, to facilitate cross-industry communications, and it's most suitable for cross-border transactions. It's impossible to imagine that a registry will ever be created between China and the US together, or other, maybe in several jurisdictions like Latin America or something. It could be possible with several countries, but having a worldwide registry is impossible. And it allows, and that's a very significant issue, it allows to demonstrate control and staying away from issues like novation and attornment, which were a very big issue in English law when we drafted our bylaws. And the reason is that blockchain allows to demonstrate that the service provider is not effectively serving as an agent in transferring the document, and as a subject to that, transferring the rights and liabilities pertaining to that document between the parties. Nobody wants the service provider to be an agent in between, and we found this technology to actually demonstrate in the legal world in the right way that is possible, and that's the way that we drafted our legal framework. So the challenges of digitization, which we are facing at Wave and working to eliminate them, is, and we're saying this out loud, and we're becoming better and better, the whole industry, in understanding how to confront these issues. So it's a bit hard to issue because all parties to the bill of lading need to be onboarded in advance and digitally identified, and that's a fact. And we are working to find some innovative solutions for that. But that's a fact that we need to understand that until today, at least, it took some time for an eBL to start being issued if you need all the parties to be onboarded. Second issue is lack of liquidity. It's hard to dispose an electronic bill of lading. If you're issuing a negotiable bill of lading and you expect to find someone to sell it to or transfer it to in case you want to get dispose of it, then you would like to not be dependent on the fact that that party is onboarded to your exact same platform at that moment. And that's a fact that until today, or until interoperability is achieved, then liquidity is harder to imagine, or high liquidity. Interoperability will definitely boost that issue. So regulators initiated different reforms, which are wonderful, but sometimes during the process of these reforms, these take time, and during that time there is uncertainty. And uncertainty is confronted in discussions with potential customers. In the end of the day, there are some corporates who just find, that they manage these assessments and they understand that this is a risk they can live with. Everything new has some risks, but the risks are small or significantly small than the risks using a paper bill of lading. And some are less reluctant to do that, and they take the time, and the world is divided between early adapters and later adapters, and that's okay. That's how the world works. Market education, most parties have to be, haven't really dealt with them before. So most bills of lading, most parties, a lot of them that are named on the bill of lading haven't really touched the bill of lading before. Now we expect them to onboard a service. Why do we expect them? That's a good question. Why do we want them to identify themselves digitally, or are we not going to? Are we going to remove that requirement? That's another good question. But we have to understand that a bill of lading names a lot of parties, which until today, they have never really understood what a bill of lading means. All these shippers, different shippers and consignees, they use freight forwarders, they use agents, and we need to all understand how we approach these parties and if we need to approach them at all. And the last point, which is the biggest challenge of our generation, is to onboard banks to these kind of services. That's a big challenge. It's even bigger than something that me or Wave can deal with alone. Banks have their priorities and the way that they look on these kind of transactions. All the issues that I named before are parts of the reasons for banks to take the time to onboard. and to go fully commercial. But in the end of the day, I believe that when there will be the more bills of lading, electronic bills of lading that will be in the market, the more we will see banks becoming active in this environment. So before I'm done, and I'm going to leave, go back to Rebecca and to Luca, I would like to give you a small glimpse at a platform, our platform, and I'm not going to dive deeply into it. I'm just going to show you 2 or 3 slides so you can just understand what you're looking at. So as you can see, it's an email service. And this is, you're looking at the basic interface used by an end customer. It's not an integrated one. An integrated one would not see any of this. It will just be integrated into his trade management system or any other office software he uses. And you can see that this is the bill of lading, what we're looking here below, and it indicates that you are the shipper and you are the possessor of that bill of lading, and it's a negotiable one. It's not touchable, so I can't step into the application, but you can see that this is how it looks. And if someone else would have received it, you would have known, if he would have received a copy, he would have been indicated that he's holding a copy of the document and he's not the possessor. This is obviously taken from the blockchain, the indication. This is how an endorsement list would look like. Clear definitions of who the shipper and consignee are, you can see above, who the current title holder is, and the signatures that appear here. And these are undisputable. And the title holder is undisputable, meaning that there is no need to screen the document. The machine can understand on its own who is the current title holder and be knowledgeable that there is no questions to ask any human being involved in this. So the meaning of that is understood. We can see there is an endorsement here from HSBC for it's just an example, yes, obviously, to a different consignee. It was issued by MSC in the beginning. And the last screen that we can see here, the network effect achieved by trusted parties, we can see how an endorsement looks like. So we need to support all kinds of endorsements. We have blank endorsements to order or to. You pick the party you endorse it to, and an endorsement signature is now applied to your document. And just like COGSA works, when that endorsee will receive possession, title will actually transfer to him. And before that happens, you'll still be the title holder, but maybe not the possessor. So that's just a small glimpse on how WaveBL looks like, how an eBL platform looks like. And I would like to thank you all. And I'm returning to Rebecca, and I'm happy to answer questions if you may have any.
Thank you, Boaz. That was a fantastic presentation. I had a couple of questions in the chat quickly about WaveBL specifically. We can just tackle those very quickly. Do participants all need to register with WaveBL in order to receive and transfer documents on WaveBL? And if so, is there a fee? Is WaveBL on a public or a private blockchain?
Okay, thank you. It's a great question. Before that, have I managed to eliminate the presentation? Great. Okay, so I'll answer that. All right. So first of all, yes, today you need to subscribe to WaveBL to receive a bill of lading. In future, it will be much more easier because subscription could be something which, let's just say, subscription could be something which is just pertaining to a specific document when you receive it. But in the end of the day, today this is the case. Regarding fees, then we have different fees depending on volumes. The fees are obviously in a compatible price to any other fees that are paid to FedEx or DHL for transferring documents. And the reward is also very nice because everything is quick and fast. About the blockchain, it's a good question. Of course, we use a private blockchain. Of course, we never issued any token, cryptocurrency. We use blockchain only as a technical implementation to demonstrate the transfer of the bills of lading. If you ever heard of the word NFT, a non-fungible token from another world, so a bill of lading, an electronic bill of lading is actually, I see it as the first NFT that existed. Only it's a real world asset NFT, because in the end of the day, it points out to a bill of lading which exists there in the digital environment, but pertains to goods on a ship.
Thank you for that. Just two other quick questions for you. Can you use electronic bills of lading for any types of cargo, consolidated, LCL, break bulk, containerized? Is there any limitation?
If there is a bill of lading, it could be electronic. That's the rule. Very simple. You upload whatever, as an issuer, I mean, as a carrier or freight forwarder, whatever bill you want. We require, or you represent that you upload both sides of the document, if it's the front and the back. So in the front, we have the different details. In the back, we have the content of carriage. You upload whatever you want. We don't see that document. And as long as it exists, until it's amended or surrendered, it still exists. If it's amended, it's reissued as a new bill of lading as far as we see it that way. I mean, you can give it the same number, but it's a different bill of lading. So fractioning a bill of lading or anything during its life cycle would be seen as different bills of lading. We should say that in future, which is not very far from today, bills of lading would be issued in the standard DCSA format of fields, less as a PDF as we see it today, more as a standard document with different fields which are defined in advance by the DCSA standard. And that means that this whole concept of document would be a bit different, and it would be interpreted, or it could be interpreted automatically because of this digitization of all these fields.
Thank you. Well, we have lots of questions coming in. So, but before we take some more, I would like very much to turn to Mr. Luca Castellani. Luca, we are very honored to have you today. Luca is joining us from Vienna, where he serves as secretary to the UN Committee on International Trade Law Working Group on Electronic Commerce. It's a mouthful. But Luca oversaw the preparation of the UNCITRAL Model Law on Electronic Transferable Records. He's also a member of the UN Network of Experts in Trade, that's UN Next, and he contributed to the drafting of the framework agreement on facilitation of cross-border paperless trade in Asia and the Pacific. Welcome, Luca. The floor is yours.
Thank you, Rebecca. Thank you, Boaz. Thanks to everyone. Thanks especially to those who are connected with us on this topic. It seems to be attracting quite a bit of attention. I was listening, of course, with great interest to Boaz's presentation. I took some notes. Now it will be some snapshots. Of course, I will not provide a few presentation on my side. The starting point is maybe something that Boaz said. He defined, among other things, the electronic bill of lading as an intangible asset, which is not wrong from a certain perspective. It's intangible and it is asset and it's electronic. But I would like to shift the perspective to an equally true statement. This is a commercial document in electronic form. We are all used to commercial documents of many types in electronic form, and many of them now are increasingly automated. We have automated contract formation, automated contract performance. To some extent, you can have automation in dispute resolution. So what we are seeing here now at last is that a commercial document that has been a cornerstone of trade and financing, it's because here we discuss from the transport perspective, But of course, this is a collateral to trade finance. Finally, we have a serious collective attempt at digitizing it and using it in electronic form. The first consequence of this is, Boaz said it, all bills of lading may be used electronically, especially the classic bills of lading, the ones that are negotiable and transferable. And not only that, but these can be transferred, they can be endorsed, but they can also circulate to bearer, which is quite interesting, as a concept in the electronic space. The problem, there were laws before. For instance, in the Republic of Korea, in South Korea, there has been a law on electronic bills of lading for maybe more than 15 years already. Or, you mentioned, thank you, the model law on electronic transfer records, MLETR or MLETR, if you want to be affectionate. MLETR, of course, came in 2017, but before UNCITRAL produced other provisions. And for instance, this is a fact that is maybe not well known, but Guatemala and Colombia and others, they have adopted those provisions, but they were not used. Instead, in the landscape, you had the solution that was mentioned based on contractual agreements and based on English law and the notions of novation and attornment, which to some limited extent reproduced certain functions of bills of lading among participants in the contractual scheme. That was not a bill of lading. It was never meant to be a bill of lading. It was meant to be a contractual document that fulfilled certain purposes. Here, now, today, we are talking about bills of lading to the fullest extent that this word has a legal meaning. What we call the substantive law applicable to electronic and paper-based bills of lading is identical. This needs to be stressed. There is absolute. That's why Boaz could say, whatever you can do on paper, you can do it electronically. Probably you'll do it much better electronically, but that's a different issue because you will have more governance and so on and so forth. What is interesting is that the MLETR was not developed only for bills of lading. It was developed for all documents that incorporate the right to delivery of goods or to payment of money. Which means, for instance, if you look at UCC Article 7, you will find both bills of lading and warehouse receipts. Why? Because both documents entitled to delivery of goods. But in US practice, and you have UCC Article 7, you have also provisions in e-sign, in UETA, you have provisions, a lot of provisions. Warehouse receipts in electronic form, no problem, been used for maybe 20 years, maybe more, I don't know. Bills of lading, very seldom, and only very recently. So the question is why? Maybe the problem was not necessarily in the law. Of course, because bills of lading are necessarily used cross-border, you need to have a cooperative environment. So now that England is adopting its own version of MLETR, that will help a lot. But for instance, Singapore already adopted MLETR, Bahrain too, and more importantly, there was a G7 commitment. And this may help also certain countries like Germany and Spain that already allow for the issuance of electronic bills of lading, but the market is not doing that because there is not sufficient guidance, and MLETR gives that guidance. So in reality, the picture is more complex than what it seems, but we are moving little by little to the implementation phase. So my final remarks are exactly on the implementation phase. I don't know whether someone who has a microphone open. It's not me. I don't know if it's possible to mute from your side, Rebecca. Well,
Maybe it's what
I have no idea.
okay, I'll continue.
Sorry
That's not, just want to say it shouldn't come from my side, but it's okay. So what I want to say with regard to implementation, the old approach, the approach from the 1980s, 1990s was to create a platform and to try to get a significant market share to be a monopolistic or oligopolistic provider. By now, we looked at each other in the eyes long enough to know this didn't work. Boaz said the key is interoperability. I have to be able to move my data from one ecosystem to the other as freely as I can. I don't want data silos. I really don't want data silos. So this opens the door to rethinking certain issues. If you look at the bill of lading as a commercial document, then you can be happy that you can have it in electronic form. If you look at the commercial transaction, then you can be happy that you put all the information related to the electronic transaction in a single electronic record that is also transferable, and you use that information to share selectively with your business partners what each business partner needs, so that you will in the end have a bill of lading. But it's not a standalone electronic document. It's a dynamic bill of lading that can be generated on the basis of information that can be updated, and by updated this information in part also thanks to we have this dynamic information coming from the Internet of Things. So a lot of that stuff is automated, and some may be manual. You have much better control over not only the bill of lading, but the whole supply chain, the data flow that supports the supply chain. So this is a bit the concept of data pipeline. And it's easier to implement exactly because all transferable documents and instruments, they have to meet the same legal requirements. And all the other documents and instruments have to meet lower requirements. So if the higher requirements for a bill of lading are met, automatically all commercial documents are fine because they all comply with the law. This is my famous statement. We have to think data, not documents. We have to move out of the box of the bill of lading as opposed to the bill of exchange or of the promissory note, and into the data that will be used to generate things. Last week, I was talking at a conference here in Vienna for bankers. Boaz said it's difficult sometimes to persuade the bankers, and I think I agree with him. It's easier to persuade the carriers than the bankers, maybe. But the bankers need to be persuaded. And I realized that in the room, we had a bit of an interesting situation. Some people knew about MLETR, many didn't, and that's why we were there, of course, because we had to. And a handful of people had in their pockets mobile phones, but inside had applications. Applications issued by banks in Bahrain that allow you to issue a negotiable electronic check based on MLETR. So there was already a very small group of people who actually could show that MLETR is at work every day. I understand that already hundreds of thousands of electronic checks were issued in Bahrain. This is because of a local need. There are special reasons to issue. This is not check truncation. I want to make it very clear. This is an electronic check that instead of being written on paper is generated electronically on a cell phone and then can be moved. what you have there is you have a device, which is a mobile phone, which people have, and you have a network, and this is maybe what Boaz was saying. Don't get any more directly in touch with the service provider, but go through an intermediary, in this case, the bank. And the bank tells you, yes, you can issue the electronic check, but tomorrow the bank can give you the application and say, you know what, you can issue the electronic bill of lading. And this will become, a quiet revolution, because we will move out of all of these paper business, which is now really creating problems in terms of fraud. It's creating problems in terms of environmental costs. It's creating problems in terms of business costs and everything else that was said. So I'm just sharing a few considerations here, maybe to feed the Q&A session and how things are seen from our perspective. Thank you.
Thank you so much, Luca, for that terrific insights. There are, it seems, then few legal roadblocks to the adoption of electronic bills of lading, but perhaps commercial and usage roadblocks, and many potential benefits to the adoption. We have a lot of questions in the chat. Would you both be available to take a few questions? I'll direct them. We had one legal question, specifically on Spanish law. There seems to be some perhaps lack of guidance, as you said, Luca, on the possibility of using electronic bills of lading, and even the definition of a bill of lading under Spanish law. Is this something that you've run across? Is there something that you can give Spanish legal practitioners by way of guidance as to negotiable bills of lading issued and transacted electronically?
I am very cautious in telling Spanish colleagues how their law is, because they know better than me. But what I can say is that the new maritime code, which I think is from 2014, takes into account the fact that Spain was one of the few countries that ratified the Rotterdam Rules. Rotterdam Rules is a treaty also prepared by UNCITRAL, and it actually deals with the bills of lading in a what we call a medium neutral manner. What I mean by that is it puts on the same level paper and electronic, which is slightly different from saying we have paper and then we add on electronic like MLETR does. So the reference is Article 262 of this maritime code, which should be Act 14 of 2014. And this Article 262 allows the issuance and use of electronic bills of lading when carrier and shipper so agree. It gives quite a bit of freedom, like the Rotterdam Rules do. The Rotterdam Rules have not yet entered into force, unfortunately, and we don't know if and when they will. So very interesting as a model, because they inspired both Spanish law and German law, but they should not be considered as a treaty in force now. But anyway, in the case of Spanish law and German law is in that regard in some ways similar. There are requirements for integrity of content, for circulation, and of the bill of lading, and then there is full legal equivalence between paper-based and electronic, and then there are some issues on change of medium. Now, whether I don't know if Spain is interested in adopting MLETR as implementing regulation for this. I think it would fit very well. but I am not aware of any such initiative. But the parties can do that, and they can also do that by for instance, adopting the terms and conditions of the service providers, including WaveBL. So there are different ways of complementing that legislation. But what is important is that legislation, which as far as I know is in force, is already saying, yes, you can, like the German legislation, but when people don't. So we are now reaching that level of maturity in the market, in the technology, in the awareness of the business operators, where we say, yes, we can, and we want to, because we have all the tools here.
I'd like to add some a bit of a let's say from the ground answer to these kind of different questions about different jurisdictions. So in the end of the day, some jurisdictions facilitated the electronic bills of lading at this stage, and some haven't. And the challenge for that regulatory change will probably take a long time to be overcome. Maybe 10 years, maybe more, until we will see the entire world accepting these kind of documents. But you will be surprised to hear that even the most notorious jurisdictions, where everyone says it's impossible to issue a bill of lading in electronic format and nobody will accept it, it's done there, it's issued. And it's done because the agency there just, got to the conclusion it's going to start doing it. The customers are doing it. The customs there, no one else is actually in reality opposing any issues. And suddenly you hear that in these kind of jurisdictions, and I don't want to say any names, but worldwide, bills of lading are already issued electronically. And the problems we thought they exist there. And I also gave you an example, Rebecca, about when we spoke a few days ago about DocuSign. When I joined Wave, I tried to persuade my CEO, let's use DocuSign. And even me as a lawyer, it was hard for me to accept it. And I wasn't really aware if the law in Israel really allows it or not. But gradually it just happened. And now the biggest contracts, the biggest exchange of documentation is using these kind of signatures. And nobody is really going to challenge that, especially not in the bill of lading platform, where there is a legal framework, as Luca said, contractual one, which agrees that all these issues are agreed between the platform, accepting, having it in electronic format, not challenging it in court by each one of them later on, and refraining from doing that. And the second point I want to say is that, and this is the point that this could maybe discuss, maybe Luca would have something to say about that, or someone in the audience, but in the end of the day, there is a law in a jurisdiction which obliges the issuance of a bill of lading. Then there is a bill of lading with a contract of carriage, which is issued in accordance with a different law, which God knows how the parties have concluded it could and should be issued by a different law, such as English law or whatever. Then enters the eBL platform provider, which introduces its contractual framework, which is under English law and is distinguished between the layer of the electronic transferring of the document and the actual contract of carriage between the parties, which remains under their law. So in the end of the day, the platform tries to make and facilitate the most easy relation between the parties, just to agree on the minimal electronic issues that need to be agreed on, and the rest are still to be dealt between the parties under the contract of carriage in the exact jurisdictions they would go in the exact same paper bill of lading. That's the philosophy behind the legal framework of all platforms, I guess. And to have a minimal acceptance, to deal with the potential challenges of the medium, the electronic medium, but leaving the parties to keep on dealing with their own commercial relations under the same jurisdictions they would do so in the paper world.
Thank you for that. We've had a couple of questions in the chat about standards and which standards bodies are already working on this, which should be working on this, which standards does WaveBL, for example, use primarily, and which is there overlap between the commercial and the banking standards, perhaps? that need to be addressed in a standards body, which standards body should that be? Maybe I'll ask Boaz to please respond first, and Luca, if you have something as well. Thank you very much.
Okay, it's a wonderful question, and I like to answer it always. We are not legislated and not regulated. We don't transfer funds. Let's start from that. There are no funds on our platform. We just allow exchanging of documents. So first of all, we're not a financial service provider or anything like that. That's a very good starting point in my day when I wake up in the morning, that I know that I don't have that responsibility on me. Secondly, what are we exactly? We're a software provider. We actually provide most of our customers a SaaS, software as a service subscription, meaning we host their data on our cloud and we need to manage it and be compliant with GDPR and compliant with different ISOs for SaaS services like 2701, 2717. These are very common in any other platform which provides software services. What else? So we have the IGP&I approval, and as we said before, that effectively until today is the only gateway for turning an eBL platform to one that you are going to work with or not. Secondly, if your distinctive issuer is working on that platform, and then he decided to work on it, and he is liable for that bill of lading and for all its aspects. So yeah, there's not a lot to be intimidated by it, because if a carrier wants to issue there, then he took responsibility of a lot of the issues there. And obviously we have insurance covering our liability. Regarding standards, we discussed before, when the carriers will start issuing bills of lading, not in a PDF, in their DCSA JSON standard, we will be the first one to allow them to do that. As far as we are concerned, they can issue it in any format they want. Also a JPEG or PDF or Word document. If they consider it a bill of lading and they're going to respect it, then we're definitely not the ones that will prevent from them. But that's up to them to decide on that, the issuer. And the last question about the banks. So in the end of the day, I don't know if you're familiar with, I'm sure you are, but I don't know how many people actually read EUCP. So EUCP is guidance for a bank how to deal with electronic presentation. I actually had the chance to analyze it several times together with our different experts, and we have a guidance, of a few pages, which we advise the bank how to be compliant with EUCP, and they find out that it's not very complicated. There are several conditions that need to be met, and they are compliant with EUCP, meaning they are compliant with UCP 500, and that's the whole idea about it. Now, if any special customer has different security requirements or anything like that, that is dealt just like any other service and offered to any customer. We have different abilities. Just to say that a blockchain service also allows the possibility of installing the software on your cloud, on your server, controlling your own data, controlling your own node. That means a lot to a lot of big corporates and banks around the world, and it could be done. Some of our biggest customers do that, but their customers, the small SMEs, they're going to work on our cloud. They will not want to install anything on their computer, because nobody installs anything today unless it really needs to.
Luca, did you want to say a word or two about standards in this field? Which international standards bodies are working on this matter, which should be, and DCSA, of course, is not a standards body, but it has created standards, and any perspective on those?
Well, we are a technical legal body, so we prepare legal standards, if you wish. Of course, I mean, there is one fundamental problem. The problem is there is a need to have well-structured data. So the data has to be readable for a use, analysis, consolidation, whatever. Really, this is at the core. I said it before, and I apologize for repeating myself. we have to move out of looking at the document and into the underlying data. We are missing out on digital transformation if we continue to think to digitizing each single document and treating each single document separately. But in order to do that, probably I am not a specialist in any way of technical standards, but I take it that probably open standards are better. I take it that standards developed by industry are better. There are many standards already. For instance, there are standards for single windows for customs operations developed by WCO. There are a lot of standards now being prepared at IMO on cargo manifest and so on and so forth. All of these things need to be put together in a way that makes sense. As a lawyer, I don't know how to make sense out of it, but I know for sure that it is absolutely necessary, because what we tolerate today, the current business procedures, we may not be able to tolerate them tomorrow. And change, a lot of people said change is coming soon, and change didn't come. So how long should be, standing on this watchtower to see change coming? But maybe now change has already come, and it's just a matter of, realizing it, and then it will have a snowball effect. Do we need this common standards? Probably yes, but Boaz said, we as a service provider, we are compatible with all the standards that you want. Just make sure that you think of all possible uses so that the standard will actually be useful for you. And I cannot but agree with that. One maybe word on the legal word, the role of the service providers. We have really to think of open ecosystems, and the service providers come in the open ecosystems and take care of their own services. But in the end, it will be in this case, the company, because we are talking about commercial operations, that generates and controls data throughout the process, that will be making the decision. Now, is that the carrier or is that the bank? That's a very good question. Maybe both, or maybe the shipper. I don't know. But one has to start asking who really owns, owns, so to say, but controls, if you wish. I don't like control, because control reminds me of GDPR. I don't like owns, because owns means property, but we have to find a word to say, whoever has interest in data and how this data is shared and how it is treated, and the way data is shared will necessarily have an impact also on technical specifications, which anyway should be open and interoperable as much as possible. That's as far as I can say, as someone who really does not understand technical standards, and apologies.
I would like to add one word to that, just to say that it's not standards, it should more be looked as self-standards, because a bill of lading, there is no real standard for how it should look, or maybe there is something which was developed across the years, but there is no real rule how it should look like. Now, if the specific issuers of sub-document decide that they want to self-regulate their own standards, they can do that. It's not a regulator who says to them, now bill of lading needs to look this way. They decide. DCSA is a voluntary organization of these distinguished carriers who decide to create their own acceptable framework, and they're entitled to do so. But on the other hand, someone else could do that or do it differently. And I'm not the one, or none of us are the one to judge and say this is good or bad. If it's accepted by the market, then wonderful.
Thank you both for that. Lots of insights here, and we still have lots more questions, but we're running up against time. And again, I want to thank both of these gentlemen for their very generous interventions and very generous time today. I think we'll have maybe a few follow-up discussions. Certainly there are lots of participants in the chat that have lots more questions. So I wanted to invite everyone who's participating today to contact me directly if you wish to have a follow-up conversation with These gentlemen, perhaps there are others who are working in the field who can give us more insights, but invite you to please follow us. The recording will be available later. Again, thank you to both Boaz Lessem and Luca Castellani. We are very, very grateful for your time today and lots of insights, and grateful for all of the interest of the participants. If you have further interest, the American Bar Association section of International Law, International Transportation Committee, we are on social media, on LinkedIn, find us on the internet, and reach out to me directly if you are interested in becoming a member, in participating in our webinars or other events. And again, thank you for everyone's participation today. Thank you, and enjoy the rest of your day.
Thank you. Thank you very much.
Thank you very much, everyone. Thank you, Rebecca. Thank you, Luca.
Thank you. Thank you again.